So what is the speedy trial rule in Massachusetts for criminal cases? The easy answer is that you have a right to be on trial within 1 year of your arraignment date. The arraignment is your first appearance in court generally, where you would plead not guilty and you'd appear and have the charges read to you in court. And the trial, of course, is the trial. That's when you pick the jury and start the actual argument as to whether you're guilty or innocent. However, that 1 year promise, that they call it Rule 36, the Massachusetts Rules of Criminal Responsibility, Rule 36 is what guarantees your right to be tried within 1 year. However, that is often extended. There are periods of time that are routinely excluded. If the defendant doesn't actually object to every continuance, then there's an excludable time period. If the defendant files a motion for discovery, or a motion for a dismissal, or a motion to suppress evidence, those are periods of time which can be excluded from the calculations. During the COVID-19 pandemic, there was wide periods of time that were just excluded for everybody. So every single person who was either sitting in jail or just waiting for their day in court, every day that passed didn't count at all. So you might hear from other people, either who you know, or if you've got a loved one in jail who's facing charges, they might hear from fellow inmates, or you might hear from fellow people who've been through the system that, oh, you got a right to a speedy trial, file a speedy trial motion. Motion for speedy trial means basically nothing. All it is a request to get a soon trial date. And courts routinely overbook themselves, and there's so many cases on in Massachusetts, there's too many trials on any given day. So if you have a trial date, chances are you may be contending with multiple other cases that are also on for trial. And courts will do this, and then as you get to the trial date, they will pick whatever trial date they want. Usually that'll go by order of seniority, or if you, let's say, are in custody, you have a right to go to trial over somebody who's not in custody. If there's a child victim involved in a case, they get priority. If a case is older, they get priority. So you could be ready for trial. The prosecutor might even be ready for trial. Everyone's ready for trial, but the court can't get to you. Then the court can say, oh, the interests of justice are allowing for a continuance, and they outweigh the defendant's right to a speedy trial. If the judge finds that in the interest of justice, that a continuance of the trial date outweighs the defendant's right to go to trial within a prescribed period of time, then that period of time, that continuance, is completely out the window. So what ends up happening is that some trial dates end up being a year and a half, 2 years before they actually get to trial. And unfortunately, there's not a whole lot that can be done. Of course, if you have an interest in trying to get this case done sooner, you can have the attorney object, or the attorney can ask for the soonest available trial date. But no matter what, if there's no trial dates that are available sooner, the judge is going to overrule it, and the judge will schedule the trial for when the judge wants to schedule the trial, when they can fit it into the court calendar. So all that's to say, it is incredibly frustrating. As a defense attorney, I routinely object. I routinely ask for sooner court appearances. But hopefully this information is helpful if you're dealing with a criminal case in Massachusetts and you want to know what the heck is happening, when am I going to get my day in court. It really varies court to court. It varies what session you're in, even within the same court. Like Suffolk Superior Court has different sessions. They have a gun session, a drug session, a murder session. And it really depends on how many cases are on at any given time. And so all that is to say, of course, as an attorney, I'm often asking for the soonest possible date. But realistically, I'm having this conversation over and over with clients, especially clients who have friends who've been through the system, or clients who are in jail and they think, I file a speedy trial motion and this is going to be the magic pill that's going to just end my case completely. Unfortunately, it's not as straightforward as that. And so all I can do, all a defense attorney can do, is to be ready to press for our rights, to request soonest trial dates that we can. And then the rest is up to the court to make the decisions and to put us on, hopefully sooner than later.